today. And King's wedding is tomorrow.
Yeah.
I don't think I can.
Oh,
make it.
Yes, thank you.
Wednesday, the 13th day of April, 2022, court via Zoom at 2:37 p.m. before the Honorable Justice Sybil Williams, Appellate Jurisdiction 2021, number 32. Lamont Marshall, the appellant, versus the Queen, the respondent. Ms. Greening for the appellant and Ms. Maria Sophianos for the respondent.
Yes, good afternoon, counsel.
Yes, good afternoon, my lady and my learned friend.
Where is Mr. Marshall?
I'm not too sure.
Were you not expecting him?
He has been here on the other occasions. I just received a link about 8 minutes ago. I had been looking in my calendar. Anyway, I'm not too sure. I'm sure I can get him on if I email him. Okay, my lady, I've sent him the link.
Okay,
He
something
does
I
not-
thought you would have done a good 10 minutes ago.
I apologize, my lady. Is he required to be in attendance at this appeal?
Well, that's standard. It's
I
not-
didn't know whether appellants were normally in attendance for Supreme Court appeals.
I'm surprised by that, Ms. Greenan. There is not usually a stringent requirement for them to attend for the Chamber's directions hearings, but for the actual appeal, it surprises me that you would think with your level of experience that you would think that the appeals would be argued as a matter of routine in the absence of the appellant.
I hope that he reads the email soon.
My lady, just to add on the notice of appeal, it says, do you desire to be present on the hearing of your appeal by the court? And it states yes with my attorney.
Thank you.
Obliged.
And that was filed by
Me.
your chambers, yes, by you.
I wrote that, yes.
So
My lady, to save the court's time, would you like to adjourn until I've notified your clerk that Mr. Marshall is available?
That's not saving time, that's wasting time. But I'm not going to start without something a little bit more concrete as to why he's not present. Ms. Sophianos, maybe you can assist me. I would have given out directions, let's see,
Yes, my lady.
on the 1st of,
The last
March.
directions were the 1st of March for today's appeal date.
right. And I mean, if these things start to happen, I may very well require appellants to appear for directions if it's going to be an issue, having it communicated to them what the hearing date is.
He's coming on now.
He's coming on? Good, thank you. All right, Ms. Greening, the court is left with no real alternative. I will set them out of dawn for the next 5 minutes and hope that by 2:50 p.m. on my clock, your client has appeared. So I'm
Okay.
just going to mute my audio and turn off the camera. If he appears beforehand or before then, you should.
I will. Okay, thank you.
Thank you.
Justice Williams, he's appearing now.
Oh, is he? Okay.
Yes.
Mr. Marshall?
Afternoon.
Yes, good afternoon. Are you able to activate your video so that I can see you? Yes, thank you.
Thank you.
So Marshall, were you not aware that you were supposed to be present for 2:30 p.m. this afternoon?
No, I was not. My apologies. I just got received the link.
I see. All right, let's proceed, please.
Yes, milady, this is an appeal, a notice of appeal having been filed on the 15th of September last year in relation to a decision of the Magistrates Court. The submissions you will see from the submissions that have been filed, the written submissions that were filed, milady, that I have narrowed the arguments down to grounds 1 and 3. I start with ground 3. The learned judge failed in his duty when he misled the self-represented defendant in respect of his sentence. On the 8th of April 2021, the appellant entered guilty pleas to 2 counts on the information sheet 21 TR 00914, which were driving whilst impaired and driving whilst disqualified. The matter was deferred with my client's consent to DUI court. On the 31st of August 2021, the appellant was in attendance at DUI court due to non-compliance. And he had spent a period of time observing in DUI court and then participating in it. And at that stage, the appellant was given the opportunity by the magistrate presiding over DUI court to either continue with DUI court or comply in future, or terminate DUI court and be sentenced. The appellant was given a clear indication from the court that if he chose the latter, he would be sentenced to 5 years disqualification from all vehicles and a $5,000 fine. This is corroborated by the magistrate being heard on the court smart recording on the 31st of August 2021 at 10:30 a.m. saying, you need to make a decision today. You can be off the road for 5 years and a $5,000 fine. And at another point he said, and if you would rather be off the road for 5 years and have a $5,000 fine. My learned friend who filed submissions today included in her bundle.
This was the then senior magistrate, Mr. Wolf?
That's correct, yes.
Mhm.
My learned friend who filed her submissions and authorities has helpfully attempted to transcribe an excerpt from that DUI treatment court, which also further corroborates our position that in our respectful submission, the magistrate presiding over that DUI court did make it very clear that if he was to terminate himself from DUI court, he would be sent back to the substantive court for sentencing, where he would receive 5 years disqualification and $5,000 fine.
You liken that to a Goodyear indication?
Well, yes, and it's very clear that he was given the option to remain in the court and comply in future, or go back to the substantive court, and that's how he would be dealt with. Now, of course, if
that was effectively something that amounted to a Goodyear indication, is that binding?
In my submission, if it's not binding, it's certainly unfair for the same magistrate to then be in that court. Of course, if it was a different magistrate and there was no formal undertaking at that stage to be sentenced in that way, then there's little that the senior magistrate presiding over DUI court may have been able to do about a different magistrate. But
do I have the case of Goodyear in front of me?
That it's not included. My submission in this appeal, milady, is that it's simply unfair and misleading for a magistrate to give someone an option in one of these alternative treatment courts to either terminate or go back for substantive sentencing, and then to be sentenced by the very same magistrate in a different manner and an excessive manner than was indicated to them in the previous court. And that's exactly what has happened here. No mention whatsoever of prison was mentioned during these proceedings. And it was very clear, if you look at the transcript in the authorities for the respondent at tab 1. I mean, I was very careful with how I did, what I chose to include from the court smart recording, because I didn't want to use any of the dialogue being used in the DUI treatment court unnecessarily. But if you
Yes.
look at the manner in which the senior magistrate was actually speaking to this appellant from the start on page 1. So we got to talk, because you're not helping yourself. And let me just say this here. The people who tell me are not saying about you in global terms. They're basically saying in terms of, excuse my language, that guy's an ass. So it's not even like Marshall's a smart man. That guy is bright. He's in DUI court and he's schooling those people. He's the man. Nah, it's not in those terms. It's in the terms of that guy's an ass. He's already got multiple offenses and he's still doing shit. Excuse my language, but those are the words. I'm just trying to get to the bottom of it.
These are the words of who is
Using the words of, I think, paraphrasing what other people, he's saying other people have said about my client.
have said to who? Or is he just expressing a view as to what
It seems as if
members of the community are saying? I don't understand.
You've come into DUI court and you're not complying. And it's not even like people, and people are saying it's not even like you're here, which is bad enough, I suppose he's saying. And you're able to teach people because you're a pretty bright guy and you're accomplished in other respects. But no, you're here, you're not complying, and you're still carrying on.
Right.
That is not an appropriate way to speak to someone, in my respectful submission, in a court. But be that what it may, he then goes on to say, so at the his next entry, Senior Magistrate John 1 Wolf 526. So we can make a decision today, because we can issue all of that today, and have you rid yourself of us and say Merry Christmas. You'll be off the road probably for 5 years. This is your third offense. What do you want to do? And he says, yeah, I think I'll do that. I mean, he's not rhetorically asking him, what do you want to do? He's actually asking for a response. What do you want to do? Yes, I think I'll do that. Okay, 3 convictions. And then the pupil is reading out his antecedents. And then if you turn over the page down to the third entry up from the bottom, where it says Senior Magistrate 1 Wolf 8 minutes. You're not wasting my time. You ain't wasting my time at all. It's your decision, not mine. Seems to me that you're taking the easy way out. You just want to drink. That's the problem there. And you would rather be off the road 5 years with a $500 fine. That's all right. You still want to think about it. So he's very clearly giving the appellant an opportunity to make an actual decision about whether he's going to terminate the program and be sentenced in that manner, or whether he's going to continue and try to comply in future. And that is the basis of my ground 3, in that it's unfair of the magistrate who was presiding over DUI court to give a very clear indication to the appellant at that time as to what would happen if he did decide to terminate DUI court, which he did, to be remitted for sentencing in the substantive court.
Mhm.
The above amounts to unfairness and an abusive process, and on this ground alone, the appellant's sentence ought to be varied at least, or quashed due to the unfairness, but at the very least varied to be consistent with the indication that he was given when he was given the
But
choice.
I'm surprised that you haven't placed the Goodyear authority in front of me. I definitely would have to refresh myself on what those principles say about an indication given by a judge, and whether or not that indication, how that indication should be treated. Because if I understand you correctly, you are likening the remarks that he's made onto the kind of remarks that a judge would make when they're giving a Goodyear indication.
Yes. Well, the Goodyear directions did come to mind when I was drafting these submissions, but I was reluctant to include them because I didn't feel that it was, I thought a Goodyear direction was something much more formal. And that's why I was very careful to.
Right. You thought the Goodyear direction was more formal?
Was something much more formal that is put together in a much more formal manner between the counsel involved and the judge.
Wouldn't that make it even more helpful in this case? Because you would invite me to treat these comments with the same formality that a court would express a sentence and indication.
Well, it would be helpful to look at it, but I was thinking that it wouldn't, I wouldn't be able to go that far, milady. And as far as I was able to go is to say that it's blatantly unfair and an abuse, and it amounts to an abusive process.
Mhm.
To give
Can I just pause you just for 1 moment, please, Ms. Greenan? I wonder if I could just get a quick indication from the Crown. What does the Crown say about Goodyear indications? Are they binding?
My lady, our position is this was not a Goodyear indication.
No, I saw that, but if I took the view that it was, is that a binding indication? What are the principles about when the court makes some sort of a, whether it's formal or informal, but when it's treated
My
with
lady,
the
I would have
seriousness
to
of
look
the,
at that. I'm not
Sorry?
sure. I would have to look at that, my lady. I'm not sure if you're aware of what happened regarding this appeal. As far as,
Sophia, I'm sorry, can I actually just sort of speak up a little bit? I'm struggling to,
yes, my lady. I'm not sure if you're aware of what happened regarding this appeal.
yes.
Ms. Greening had been on vacation and the Crown never received the submissions.
Oh, no, I'm quite sympathetic to your position.
Yes, so.
Yes, I'm aware that you filed your submissions only today.
Yes, because I only received the submissions of the appellant on Monday
Yes.
afternoon.
Yes,
So I haven't had the opportunity to look at everything that I wanted to look at, and now.
yes, I make no criticism of you in that regard, Ms. Sofianis.
So I thought that maybe Ms. Greening was alluding to this being a Goodyear indication, but I have not had the time to research that. But our position is that there was no promise made and there was no promise accepted by the appellant. If you look at the full transcript.
And it sounds to me at the hilt of it that Ms. Greening is asking for that to be treated as a sentencing indication. And her arguments, I think, definitely warrant a reply, because she's pointed me to a transcript which on the face of it arguably suggests that the senior magistrate caused the appellant to form a view that that's the alternative to him coming out of the DUI program. So I'm just wondering if it was to be treated at its height. Let's say that I was with her as much as the court possibly could be in my view of those comments, to the degree that they are in fact a sentencing indication. My mind immediately goes to the question as to whether or not, as a matter of legal principle, any such indications would be binding anyway.
Well, my
Even if
lady,
it was a formal indication of sentence.
I would say no, because when the appellant heard that it could be possibly a 5-year disqualification, he said, no, he doesn't want to accept anything that severe in any case. So
He wasn't want to.
they say, maybe I should turn up my Zoom volume.
No, yeah, I don't want to invite you to just get into argument. I really was calling it upon you just to see if you took a view on the Goodyear principles when it comes to formal indications. Because I understand Ms. Greening to be saying that her argument is about fairness and et cetera, but if the issue of fairness is dealt with in that authority, I wonder if that's an authority that should be quite quickly placed before the court.
I have it here. I can forward it to you, my lady.
Would you please?
A few minutes. Yes, my
Thank
lady.
you. All right, and then I'll come back to Ms. Greening then. Thank you very much, Ms. Sofianis.
Obliged.
Yeah, well, before we even get to the Goodyear direction, if this is not an indication as to how he would be treated in magistrate's court if he into the substantive court to be sentenced, then I fail to see what it is. It's difficult to imagine what my client would have thought, other than that when he goes to be sentenced, this is how he will be dealt with. And indeed, for what it's worth, those were my instructions and the basis of this appeal for that very reason. Because on the day that he was sentenced and sent up to Westgate, he instructed me immediately to file an appeal on the basis that he was told quite clearly that this would be how he would be treated. And it was a complete surprise to him, given that he was provided with the opportunity to stay in DUI court and avoid a prison sentence if he took that decision. It seems clear to me that it can't be anything other than abuse of process, particularly egregious that the same magistrate that then made that indication just weeks prior then went on to change their mind and sentence more harshly, which also resulted in my client's employment being terminated.
What was the sentence date? Sorry.
So the sentence date, I think
Yes,
it
when
was
was-
the 13th of September 2021.
Thank you.
He was then sent back to the substantive court on an indication of his choice to do that, where he was sentenced to 5 years disqualification, a $5,000 fine, and 6 months imprisonment. While the case gets sent to us, shall I move on to grounds 1 and 2, milady?
Yes, you absolutely may. Thank you.
Grounds 1 and 2 are the sentence was manifestly excessive and the sentence was contrary to law. And it's a little bit complicated because we have to look closely at these different sections of the Traffic Offences Penalties Act and how they relate to disqualification and fines. But in section 2, subsection 3 of the Traffic Offences Penalties Act 1976 provides the law on how to deal with previous convictions in relation to sentences of fines. That's not disqualifications, just fines.
Sorry, where am I looking?
Sorry, these are my submissions.
No, you just referred to the Traffic Offences Penalties Act. We're in there.
Well, I've also included the Traffic Offences Penalties Act at the back of my submission.
Yes, I see that. Sorry, where in the act are you
Yes,
referring to?
section 2, subsection 3.
Thank you.
And I've copied it in my submissions. It says, where in head 5 of Schedule 1, different penalties are specified for second, third, and subsequent offences, as they are in the schedule, against the same section committed within 2 years of the date of conviction of a first offence, only offences committed within the 2 years immediately preceding or after the coming into operation of this act shall be taken into account. So you have to look at the offences that were committed within 2 years of the date of the conviction, not the commission of the offence, in relation to fines. In paragraph 6 of my submissions, my lady, in this case, the appellant shall be treated as having committed a third offence, the appellant's convictions being outside the 2-year period counting cumulatively as his first offence, and the conviction of the 12th of June 2020 counting as his second offence because it's within the 2-year period, and his current offence as the third one. According to section 3 of the Act, in relation to disqualification, which is different from fines, head 6 of Schedule 1, the appellant shall be treated as having committed a first offence, the date of the commission of the offence, as opposed to the conviction, being the 6th of October 18, being outside the 2-year period preceding the date of the current offence, the 1st of April 2021. Section 3.1 reads, in this section, reckonable offence means an offence against a provision of law specified in heads 1 and 2 of Schedule 2 of a description specified in head 3 of Schedule 2. So that's the definition of a reckonable offence. Where a person is charged with a reckonable offence and he has within the 2 year preceding the date of the commission of the offence been convicted of a previous reckonable offence, such previous disqualification that may be imposed on his conviction of the offence charge be deemed to be a previous conviction of the offence charge, and the court may disqualify him accordingly. Provided that in each group of Schedule 2, the offences therein specified shall be reckonable inter se, the offences specified in Group 1 shall be reckonable with the offences specified in Group 2, but not conversely. And that is to say, in paragraph 8, therefore, in relation to count 1, which is a driving whilst disqualified count, for an offender having committed a second offence within 2 years of the date of the conviction of the first offence, the Act limits the sentence to $1,000 and 6 months imprisonment and a discretionary 5-year disqualification. In relation to count 2, which is the driving whilst under the influence, for an offender having committed a second offence within 2 years of the date of conviction of the first offence, limits the sentence to 5,000 or 2 years imprisonment or both, and an obligatory 3 years disqualification. It is in light of the above, it's submitted the appellant ought to have his disqualification reduced from 1 of 5 years to 3 years. I see that my learned friend's submissions in relation to this are quite different. And I'll let my learned friend go through them. But those are my submissions in relation to grounds 1 and 2, that the sentence was over and above the unfairness and abusive process in relation to ground 3, manifestly excessive and contrary to law. The other grounds, or ground 5, was abandoned, in that has already been dealt with in a previous case of Nicole Tucker. In conclusion, milady, in light of the above, we respectfully request that the appellant's appeal be allowed and his sentence to 6 months imprisonment be quashed altogether, and his sentence to 5 years disqualification be reduced to 3 years, should say disqualification, not imprisonment.
Yes, thank you. So you complain about the disqualification in relation to the ground that it's manifestly excessive, and in terms of the abusive process, you complain in respect of the term of imprisonment.
Yes,
All right.
and I have received the Goodyear quick case now.
Yes, I have as well. Do you want to look at that or
I'm
apply on it? What do you
going
want to?
I'm going to look at it while my learned friend makes her submissions.
Okay.
I'll try and do both.
And because it's just come before me, if you make any submission on it, I will allow the Crown to respond to you on that as well.
Thank you.
Yes, Ms. Sophianis.
My lady, for just transparency, I haven't had a chance to have a look at the case yet.
Yes, Ms. Sophianis, I'm going to trouble you again to ask you if you can raise your voice. Your audio is not as clear as Ms. Greening's for some technical reason, I suspect, but I just want to make sure that your voice does pick up on the court smart.
Yes, my lady, I did test it prior to starting, and it was quite loud, so I turned it down a bit. Is that any better now?
Not particularly, but if you can just make an effort to keep your voice raised. I have noticed recently enough that some of the court smart audio is not as clear as it usually would be if we were in the courtroom.
I'm obliged.
All right, thank you.
So my lady, yes, the Crown's position, the respondent's position does vary from that of my learned friend, Ms. Greening. First of all, we can go back and look as to what happened in the DUI treatment court on the 31st of August, 2021.
Yes.
As I stated earlier, I did quickly try and have the hearing transcribed, and one of our young administrators in the office took to task on that, and I checked through it last night.
That's tab 1, which Ms. Greening was reading from, right?
Yes, my lady.
Okay.
And going back into the language that was used by the former senior magistrate, my lady, my understanding of that the learned senior magistrate was talking as if these people were coming up to him discussing the issue with Lamont Marshall and whether or not he was being serious about being in the program and the things he was doing. So the language that he was using was in reference to people coming up to him, and this is what they're saying. And he was having this conversation with Mr. Marshall.
Ms. Greening says that's inappropriate. It's inappropriate language. What do you say?
Well, my lady, I would say that the treatment courts are a little bit different to the regular court setting.
Right.
Sometimes there is some casual language that goes on.
Mhm.
And, you know, sometimes there's an opening up that you don't see in some of the other courts. That's the nature of the helping courts in this jurisdiction and in others.
Right.
So sometimes there's a basic conversation that goes on. And at this time, the appellant was being challenged about a report of him drinking at Ocean View Golf Course. And that was his being non-compliant with the conditions that are usually set out in that program. And, you know, they were talking on a that sort of level. And then at that point, Mr. Marshall is conceding and apologizing for his actions. And he was saying, well, yeah, I did drink, but I wasn't driving. And that was the big issue for me. And of course, you know, there's a zero tolerance for drugs and alcohol in those treatment courts. So the senior magistrate at 526 is saying to himself, well, we can deal with this today. You could be off the road for 5 years. This is your third offense. What do you want to do? And of course, we know, and Mr. Marshall would himself know, he's been before the court for many of these types of offenses before. That wasn't a total indication that was given. It was a discussion that was going on. And Mr. Marshall responds, yes, I think I'll do that. And then there's a discussion about the previous convictions, of which he's had 5 or 6, I would submit to this court, of the various types of these types of offenses. And then he goes on at the bottom of page 2 at 8 minutes in. And Lamont Marshall first says, well, I don't want to waste your time anymore. And the learned senior magistrate says, you're not wasting my time. You're not wasting my time at all. It's your decision, not mine. Seems to me that you're taking the easy way out. You just want to drink. That's the problem there. And you would rather be off the road for 5 years with a $5,000 fine. That's all right. You still want to think about it? Now he's putting, I would say, and submit to the court, he's putting the view of what the appellant wants to happen, not necessarily the view of this is how the court is going to action and sentence this matter. And then this is important, I would submit. The appellant responds, no, I won't do it now. I mean, not with that severity. I'll stay in the program then, right? So he's already realizing that it could be a potential for 5 years disqualification. And he's saying, no, I'll stay in the program at that point. And Ms. Mills from Department of Court Services goes on to say he was discharged from the Turning Point Treatment Center. And Mr. Wolf talks about the benefits of these types of treatment. And he says at page 3 at 923, so this is what we need to do. If you want to maintain your position next week, and then there's an inaudible, what you need to do, you need to find out if you made in the program. And he says, you understand? And he says, yes, sir. And the senior magistrate says, we're going to mention this case on the 7th of September at 3:30 p.m. in respect of whether the defendant wishes to remain in the program and or sanction. Thank you. And then it's put off. And on the return date, Magistrate Chin is sitting on that date. And then if I can take you to my submissions at page 2, looking at the chronology of appearances, we now know what happens on the 17th of September. The appellant appears and Magistrate Chin was presiding. And at that point, the appellant confirmed he no longer wished to be a participant in the DUI treatment court program. So there you have the defendant vacillating from saying he wants out, saying he wants in, and then now he's saying he wants out. Of course, we know by this time there's some issues with him having resumed drinking alcohol and things of that nature. And earlier on in the recording, the senior magistrate was challenging him on the fact that by the time he gets tested by Department of Court Services on the Monday or Tuesday, any alcohol he has consumed over the weekend has metabolized by then and doesn't show up in tests. So at that point, it's put off to the 13th of September and it's put off to sentence. And we're aware of what happened on that day. And no separate fine was given for count 1, the disqualification, but the appellant was sentenced to 6 months imprisonment on that count. And this is where we would concede in some way, my lady, because we would say the maximum penalty on count 1, if you look at the Traffic Offenses Penalties Act, and that's in my tab.
Sorry, before you go on to the question of maximum penalty and whether it's manifestly excessive, can you just come back to the argument that Ms. Greening makes as to the fairness of issuing a sentence that is other than what was indicated at an earlier occasion? Because you've characterized the comments by the senior magistrate as somewhat being a summary of what the appellant would have liked to have seen happen.
Yes.
Can you just explain to me how I might make that type of construction from the transcript?
Well, at page
There's some questions on the top of page 2, or put it this way, the Crown is advising the court about the history of the previous offenses.
Yes, my lady.
That exchange continues between the Crown and the senior magistrate.
And the senior
And then
magistrate,
next thing you know, the senior magistrate is basically stating what the appellant would prefer to happen out of his two seemingly only alternatives, either to stay in the DUI program or to face 5 years off the road with a $5,000 fine.
Yes, but I would say that no indication was given that prison is not factored into any of those ideas.
But is it not strongly implicit that this is the fullness of what would happen? So for example, if prison was something that the senior magistrate was live to in the moment, wouldn't that be a point that he would make in the context of this exchange? Wouldn't he say, so you would rather go face 6 months imprisonment, $5,000 fine, 5 years imprisonment, 5 years disqualification? Wouldn't it be more likely that if that was something that he was live to in that moment would have actually included in the making of this point?
Well, my lady, he could have said it. I think at that point, they're going back and forth to try and figure out how many priors he's got. And he's going back and forth with the Crown, trying to get those dates right. And he's saying, was there a third offense? So I don't know if they had actually reached a total agreement between the Crown and the court as to what the position was and whether or not the senior magistrate would have had all that material in front of him at that time to give a full indication. So I
No,
was,
it doesn't seem to me that he was in a position to, let's put it this way. It's not as if he had been fully addressed on what the sentencing options would be.
yes.
Be that as it may, having been addressed somewhat on the subject, he's then turned from his exchange with the Crown to an exchange with the appellant to say, so you would rather have this than that. That this is the sentence as he described it, and that is the DUI treatment court. Isn't it strongly implicit that the indication from the court is that this is what you would be facing if you come out of DUI court? This is what your sentence would look like.
Well, my lady, I would say it was conversation, but then you have Mr. Marshall, the appellant, saying, I don't want the severity. So he withdraws from any sort of acceptance of that being the ultimate outcome in any case.
Well, he's expressing, well, if I read correctly, I mean, not with that severity. You say that he's referring to the severity of the sentence described to him?
It seems so.
Would that not strengthen the point that Ms. Greening makes? That he's considering in this moment, his understanding from the court is that the worst case scenario that you're looking at is the $5,000 fine and the 5 years disqualification.
I would say not, because I would say that the learned senior magistrate did not go as far as to say, look, this is exactly what we're looking at. This is what you have in front of you. We have to go look at all your priors.
Well, that would be express, but I'm
Yes.
saying, is it not strongly implicit?
I would say, no, my lady, I would say due to the nature of the way things are discussed in that court, it was a back and forth. And I don't think we had reached that point yet.
Okay, and bearing in mind that, again, I am sympathetic to how you've been given very short notice of the arguments. So if you wish to just put off addressing this question to a later part of your submissions, maybe even in your response, you can think about it. But the next question I would have for you is, if I'm not with you on that, and if I look at this and I say, no, I think Ms. Greening is right in her characterization of the exchange, it was clearly an indication from the court as to what the sentence would be. Then I come back to my original question as to whether or not on the principles that apply to that kind of scenario, is it, number one, binding? And if it is not binding, do those legal principles which say it's not binding deal with the issue of fairness?
I'm obliged. I'd like to think about those two issues. Please, my lady.
Yes.
Okay.
And I'm happy to allow you to address me on that in your response if you wish. I think the court should be understanding to your position. So if you want to move on to now the manifestly excessive portion, that's fine.
Well, my lady, before we get to the manifestly excessive portion, I think we, all of us need to be on the same page as to what the appropriate sentence was. And if we could start with count one, looking at the disqualification,
Yes,
I think the Crown would need to concede, because my understanding for the for the penalty for this driving whilst disqualified, if you look at tab 3, which is portions of the TOPA in my submissions. And if you go to page 32 of the Traffic Offenses Penalties Act 1976.
okay, one moment, please, sorry. All right, you said I'm looking at the Traffic Offenses Penalties Act now,
Yes, it's page 32.
and where am I looking in it?
We're looking at section 123, the Motor Car Act 1951, driving a
The
motor.
Motor Car Act.
Yes. No, it's the Traffic Offenses Penalties Act.
Oh, in that portion, okay, thank you.
Yes, so we're looking at page 32, which should be in my tab. Tab is that? Tab.
Yes, I see it, thank you.
Yes, so if you also, while the court looks at that, if you look at page 15 of the record,
Mhm.
and this may be why some confusion came into place, possibly for both sides. It seems that the appellant has a previous conviction for driving whilst disqualified incurring on the 20th of August, 2009. You see that, my lady?
Yes, I see it, thank you.
The TCD printout. So but if you look at the traffic offenses TOPA, it says on head 5, if first offense, it's a penalty of $1,000 or 3 months. And it says if a second offense committed within 2 years of the date of conviction of the first offense, $1,000 or 6 months. If the second offense in any other case, it's $1,000 and 3 months. So I would submit to the court that the appropriate penalty should have been for the disqualified driving, a fine of $1,000 or 3 months.
Mhm.
And the court did not impose a fine for count 1, but it imposed 6 months imprisonment. So the Crown would concede that that was ultra vires, in that it should have only been 3 months imprisonment.
Right.
So now I'm looking at what was available to the court before we get into what actually happened. So our position would be that it was one or the other. So he didn't do a separate fine, but that should have been 3 months is what our position is. Yeah. And I think Ms. Greening was of the view it might be 6 months. So maybe she was looking at that second part of head 5.
Mhm.
But the previous offense was 2009. So I don't agree that that should be.
He would have had to have operated, you say, under the second offense in any other case.
Yes,
All right.
I agree.
yes.
Mhm.
I'm obliged,
Okay,
Ms.
that's
Greening.
helpful.
Okay, so then we have a look and see what happened with count 2. And count 2, it was a prison sentence of 6 months concurrent with that of count 1. No separate fine for count 1, and a fine of $5,000 to be paid within 3 months of release, and disqualified from driving all vehicles for 5 years.
Mhm.
Right. So we dealt with count 1. Now looking at count 2, my lady. I've gone back and looked at, and I think my paragraph 13 in my submissions was a little bit confusing. I've gone back and looked at all the previous offenses of the appellant. And it is our position that 35AA is different.
Ms. Sophie, I'm sorry to tell you, this is so difficult for me. I'm struggling to hear you. I'm trying to focus very clearly, but every time I turn a page, I feel like it muddles your voice. Is there anything you can do with your audio that
Well,
might assist with this?
I've had feedback from people on YouTube and they said it's quite loud. So I think it is something to do with the Court Smart.
No, I can't hear you very well either.
No, I hear Miss Greening just fine.
Yes.
It's really, really difficult from my end. And even if other YouTubers happen to hear you fine, I'm the one that really needs to hear you.
Let me see, my lady, if I can change the volume on here. Grave indulgence, video settings. Okay, let's have a look. Audio. How about that? Is that a bit louder?
Much. That's much better.
Okay, here we go. Okay, so we're looking at count 2 and the section 35AA of the Road Traffic Act. And going back and looking at previous. Now, one thing that was interesting to me is that we had all the previous convictions confined to the TCD printout at page 15 of the record. However, the Supreme Court convictions, Supreme Court case number 2012, number 38 on page 71 of the record. For some reason, they're not included on the TCD printout.
All right, one moment. I see.
Yes, and I don't know why that happened, but that would have been before the court because it's formed part of the appeal record.
Yes.
Yes. So if I can go take the court through the chronology, this is my understanding of the chronology. I've also included the indictment for that matter, number 38 of 2012. It's tab 2 on my authorities, my lady.
Mhm.
So if we go back and look at the full chronology, on the 4th of June, 2009, the appellant.
What am I looking at now when you took the 4th of June? Where's that noted in your submission?
So you would have to switch. Yes, it's in my submissions on paragraph 13.
All right.
Where I talk about like offenses, not necessarily the same offenses, but like offenses.
Right.
So if we look at, also looking at the TCD record and the.
Ms. Sophianis, I now have 3 documents open at the same time.
Oh, yes.
Fingers and Post-its on them. Do you want to?
My lady, I forgot you're very digitally.
I'm just trying to follow the documents as you say it. Is it necessary for me to open the next document?
Okay, so you can look at, yes, please, page 15 of the appeal record.
Okay.
And let's look at what I say is the chronology of these types of offenses that this defendant has committed.
Yes.
We look at the 4th of June, 2009, having incurred on that date, that's
Yes.
excess 80, right?
Okay.
Alcohol. The next one, I would say, which is more related to count 1, was driving whilst disqualified on the 20th of August, 2009.
Yes.
The next one would be the Supreme Court matter,
Okay.
which we only have the certificate for. It's not on the TC
Yes.
printout. And
Yep.
that offense was committed on the 13th of August, 2012.
Mhm.
That from the indictment that I provided to the court.
Yes.
And we flip back to the TCD printout. And we have on the
Where's
14th
that TCD printout? What page am I looking at?
page 15 of the record
Oh, the
again.
same 50. Yes. Okay.
Yes, so we have impaired, that's an impaired driving offense. So
That's the 14th of August.
14th of August.
Yes.
And on the 12th of June, 2020, we have a refusal, right? So while I say these are all like offenses before the court, of importance when we think about the same offense, if we look at the one in Supreme Court, that would have been causing GBH by impaired driving, 2 counts of that he was convicted of.
Right.
This matter before the appeal for count 2 is actually a lesser and included of those. So I would say and suggest to the court, they should be treated in the same way.
Right.
And on the 14th of August, 2015, we have impaired driving. And then the matter that forms count 2 of this appeal. So I would say that's 3 impaired driving cases.
So this comes down to a question as to what's a previous offense. Is that
Yes, my lady.
most of it?
And this is why I would say that we differ, I believe, from my learned friend, because if you look at section how 35AA is dealt with in Schedule 1 of the TOPA.
Okay, let me just pause you for a second. Your final date in the chronology was 12th of June. What's 12th of June?
12th of June 2020 was a refusal.
Okay, where in the record can I mark that?
Page 50 of the TCD printout.
Oh, I didn't see that. Okay. Oh,
At the bottom.
oh, I see it right below. Yes. Okay. So
Yeah,
that's number 5. Okay, so those are 5 points, 5 stages that you've taken each in
Yes.
chronology. Thank you.
yes, and all of which I would be suggesting was to the mind of the senior magistrate when he's dealing with this matter at sentence. So if you look at the TOPA, page 17 of TOPA,
Yes.
which speaks to the Road Traffic Act 1947, section 35AA.
All right, give me a moment.
Mhm.
Yes.
This is somehow different because this doesn't talk about offenses having been committed in the previous 2 years. It doesn't expressly provide for that in this section. And if you turn to Schedule 2 of that same section, which is at page 35,
Mm-hmm.
section 35AA is not expressly provided for in that section regarding reckonable offenses. And we would submit that.
Sorry, can you repeat that last point? So under Schedule 2 reckonable offenses, what's not included?
35AA. This
Oh, I
is
see.
section. However, what is
Okay.
included is the old section 35(1), 35 brackets 1, driving or attempting to drive motor car, auxiliary bicycle while under the influence of alcohol or drug.
Mm-hmm. All right.
So by this section, it does not expressly appear in Schedule 2.
Right.
And I would like to show the court the difference between how that is averred in TOPA. If we look at something like the speeding offense, which can be found on page 10 of Schedule 1
Yes.
of TOPA, we flip back to the speeding offense of how it is listed in Schedule 2.
Yes.
It's listed both in Group 1, whether or not you're above 60 kilometers per hour, and it's listed in Group 2 if you're below 60 kilometers per hour, all in Schedule 2.
I mean, all of this is just to simply say the absence of section 35AA under Schedule 2 is not is not any kind of an oversight. It's a deliberate and very relevant absence.
Well, that would be our position because it does not go into mentioning those terms of within 2 years of the date of conviction on all of those terms as it is, and you see it in the speeding section
Right.
in that same act. So for that reason, it would be our submission, my lady, that when the senior magistrate turned his mind to this sentence for 35AA, he went straight to the head 5, if a third or subsequent offense. And we say there is nothing wrong in him in doing so. And that says if third or subsequent offense, it's a fine of 5,000 or 2 years imprisonment or both. And if a third or subsequent offense, it's obligatory 5 years imprisonment. Yes, my lady?
So I think
Disqualification.
you just read my mind because you said that before I actually said anything, but just so that I'm noting this correctly. So no, one moment. Sorry, one moment. What page is the information on, please, in the record?
Page 11, my lady.
11? Thank you. Okay, thank you. Okay, now I follow, I believe I follow you. So when you say that he treated it as if it was a third or
Third,
subsequent offense
yes,
in respect of count 2.
yes, correct.
Okay,
And what's also interesting, my lady, and I'm not exactly sure if the act provides for it, is that often in court, when we think about excess 80 or refusals or impaired driving, her ladyship will be aware that if somebody pleads to one, the Crown normally offers no evidence to the other. There's normally no separate way of dealing with it. We take one and one goes. And that's the way it's normally looked at. And, you know, in thinking about this appeal, if it has to be that it's looked at as the third offense, because if someone gets a impaired driving, say in January, and they're put off the road for 12 months, and they come back on the road the following February, say, and then they get a excess 80, and then again, they're put off the road for 12 months, and then they get a refusal. That can't be the way that this should be looked at because of the severity and importance of looking at these kind of offenses and the risk to the public of people that continue to be impaired and drive or have care control of vehicles or are over the limit or refuse to provide a breath sample. So surely all of these are looked at in the same sort of view. And I would submit that an appellant can seem to reap the benefits of going back and forth and how they're going to plead if they are a continual offender. And I would submit to this court that this appellant over the years seems to be that type of offender. Notwithstanding that he may have a serious problem with alcohol. And we know that from his previous offense where he caused grievous bodily harm to two people.
Sorry, can I just correct the Crown? In relation to, maybe this will answer why the TCD record doesn't include the offense for which he was in Supreme Court. The offense for which he was in Supreme Court, which is the indictment of which is included in the Crown's authorities. He didn't actually ever get convicted for GBH or any impaired offenses. He was convicted in the end of injury by dangerous driving only. So whilst I don't dispute a lot of what my learned friend is saying in relation to the last portion of her submissions just now, it's important to correct that part.
Yes.
I'm sorry, can you just reconcile that, please, Ms. Greening, so I can see?
If you look
your
at the
point
if you
made
look at the
at paragraphs, sorry, page 71 of the record, when we're looking at that certificate of conviction issued by the then assistant registrar refers to the disposal of this indictment.
Well, what I'm looking at here is
I meant that as a question.
Yes.
Okay.
She's
And-
correct, my lady. I have to concede on that point, and that's my error.
the amended indictment shows that he was charged with 1 count of causing GBH whilst impaired or under the influence, 1 count of injury by dangerous driving, and 1 count of causing GBH whilst under the influence, and another count of injury, but is that the same page? Dangerous driving, and a 5th count of failure to or refusal to comply. What my client.
No, I can see that. Yes, I've just married that up with the certificate of conviction. I think
What he was
that's consistent.
convicted of in the end was
Count
nothing
2
to
and
do with
count 4.
impaired. Yes.
Okay.
Um,
Count 2 and count 4.
And just to save time, perhaps, I have no issue with what my learned friend is submitting to the court in relation to these, how the court, or what the intention of the legislation was when looking at the reckonable offences and the relatively small distinctions between over the prescribed limit, impaired, etc.
Right.
As
But you just say that factually, it just does not arise in this case.
well, in my case, I'm saying that in relation to count 2, which is the impaired driving charge on the information sheet, he should be treated as having committed a third offence, which I stand by in light of the correction that I've just made.
Mhm.
My lady, I'm grateful to my learned friend for pointing that out, and that was my error.
Mhm.
I was looking at the counts rather than the final disposition, and I do appreciate
Yes.
that. Which brings us back to the question of whether or not we look at this as the second impaired, or whether or not there is movement to appreciate, do we look at other similar offenses under the act and count them in that way? And I don't know if we can go that far, my lady. If you look at page 2 of the Traffic Offenses Penalties Act, the interpretation section,
I'm sorry, just so I don't get confusing for you, take me through that. No. You. So how does what Ms. Green just point out impact on count 2?
well, my lady, it impacts in that it seems to be that my learned friend is saying the impaired driving count from the 14th of August, 2015
Mhm.
was the first impaired driving. And then the one on the 1st of April, 2021 is the second impaired driving. Is that the position of the appellant? And is that how my learned friend gets to say that we're looking at second offense? Oh, sorry.
Are you asking Ms. Greening or?
Yes, I was interested to see what Ms. Greening's position was, because if Ms. Greening is saying we're looking at the second offense, is part of that submission that Ms. Greening is accepting that the first offense would be the 14th of August, 2015? Or is my learned friend saying that she's interpreting the first offense to be the refusal on the 12th of June, 2020? And are they interchangeable?
Well, from my reading of section 2, subsection 3 of TOPA, I'm saying that all of his convictions outside the 2-year period counting cumulatively as one offense. So no matter whether he had 1 or 20 offenses outside the 2-year period, that's all to be counted as one offense. The conviction of the 12th of June, 2020 is his second offense, because that's an offense that's a conviction that has taken place within the 2-year period, and then that his current offense is his third. Because if you look at the section, which I've copied just above in paragraph 5 of my submissions, where in head 5 of Schedule 1, different penalties are specified for second, third, or subsequent offenses against the same section committed within 2 years of the date of conviction of a first offense, only offenses committed within the 2-year 2 years immediately preceding the coming into operation of this act or after the coming into the operation of this act shall be taken into account for the purposes of determining whether the offence in question is to be treated as a first, second, third, or subsequent offence. And any offence committed at an interval prior to that 2 years shall be treated as a first offence. My interpretation, I mean, at the time of putting these submissions together, I was right on point when everything prior to the 2 years shall for such purposes be treated as a first offence. So I have looked at all of the offenses, all of the convictions prior to the 2 year period, and they cumulatively come to one offence. Then I looked to see whether there were any convictions within the 2 year period prior to the current one, and there was one, the 12th of June 2020. So that counted as the second offence. So to explain my interpretation of this, whether or not Mr. Marshall was convicted of impaired driving or injury by dangerous driving in the Supreme Court kind of is irrelevant, because the fact that he's
I think you're clear. If it was before 2009, whether it's whatever the natures of the offenses, no matter how many offenses were committed, if it was prior to 2009, it's one offense and it should be treated as a first offense because it's section
not prior to 2009, but prior to 2000.
prior to 2 years, sorry.
Yes.
If it was outside of the 2 year previous,
yes. So
period.
if he had 20 convictions or one, it treated as one prior to the
Period.
2 year period. Within the 2 year period, you're then able to count how many there are. And in Mr. Marshall's case, the appellant's case, there was one. So now we've got two. And then we've got the third offense, which is the current offense, which is treated as the third offense. That's in relation to how the magistrate deals with how Mr. Marshall ought to have been sentenced in relation to his fine. Then you have to look at section 3 to look at how he should be dealt with in relation to disqualification, which is a different situation altogether, which is looking at the appellant shall be treated as having committed a first offense, the date of the commission of the offense, not the conviction, being the 6th of October 2018 outside the 2 year period preceding the date of the current offense, which is the 1st of April 2021. And so you're looking at in that case, you're not in the case of looking at how to disqualify him. Section 3 doesn't give you that cumulative option. It says you have to count everything within the 2 year preceding the date of the commission of the offense. And so in relation to count 2, for an offender having committed a second offense within 2 years of the date of conviction, the act limits the sentence to $5,000 or 2 years imprisonment or both, and an obligatory 3 years disqualification. I don't think my learned friend is disputing that. Of course, in my respectful submission, none of those things are particularly relevant in light of the indication that the senior magistrate gave to, but we've been through all of that. Well, I subject to my comments on the Goodyear case.
Ms. Sophianis, you may continue, or you may take some time to review this if you wish.
I think I would like to take a little bit more time to review it, my lady.
Yes.
I'm not quite sure I'm on board with my learned friend submissions about section 2, subsection 3,
Mhm.
how that is applied.
Mhm.
Because my understanding that really was for situations such as the speeding offense that we looked at earlier. When they expressly talk about, when the drafters have done it in such a way to expressly talk about within 2 years of a date of conviction and things like that. All of the heads talk about a first offense, a second offense, a third offense, mostly all of them in any case.
Well, I have to say, I believe that I have followed Ms. Greening's submissions, but I do think that these are the kinds of submissions that should have been made known to the Crown much earlier than they were. And I would like to have a considered reply from you as opposed to unfairly allowing you to feel the pressure of making a reply with so little time to properly respond.
I'm obliged, my lady.
So that being said, why don't we just, let's see, it's 3:53. Let me just look at the calendar and see if we could just find a date now to come back.
Can I just inquire, my lady, is my learned friend saying that if the court agrees that a Goodyear indication was given, and is my learned friend inviting the court to say that this matter should be stayed because it was an abusive process? Is my learned friend going that far, or just in relation to the penalty of imprisonment? Is that what my learned friend is saying?
Yes, that's what I
Well,
said.
I think it's a good question.
And that is what I said, that in the first instance, my submission is that this conviction should be quashed altogether due to the unfairness and abusive process. And in the alternative, that the appellant should have his prison conviction or prison sentence overturned.
I'm obliged.
But the more I look at this Goodyear case, the more I see that, you know, notwithstanding this unusual situation of going into DUI court, it seems to be on all fours with what the learned magistrate indicated and did, and what my client did as a result of that indication. My learned friend talks about DUI court being different and how there's a conversation between people in that court. But what she failed to remember is that there is a serious power imbalance going on in that conversation between a judge and a defendant. And that serious power imbalance needs to be held in the forefront of our minds when we're looking at this, the words used in that conversation between the parties.
All right. We can come back next week, Wednesday at 2:30 p.m.
Crave your indulgence, my lady.
Yes.
Yes, my lady. That's fine for the Crown.
Thank you. And I think you should just have a look at this, Ms. Sophiana, so I can have a fully considered response from the Crown.
I'm obliged. So would you like me to file something maybe Tuesday, my lady?
That would be very helpful. I would be assisted by some submissions that address the points Ms. Greening has clarified this afternoon.
I'm guided, my lady. I am on vacation tomorrow, so I would like a little break, but I can work on that on Monday.
Yes,
client-
every member of the
client will
legal
be in
profession, I'm
attendance.
sure.
My client will be on time and in attendance next Wednesday.
Yes, thank you. Yes, Mr. Marshall, we're going to come back in the same forum.
He seems to, oh, he's there.
So we will be back by Zoom if you don't get, in fact, the court, I would imagine, will likely send the Zoom details to Ms. Greening, and Ms. Greening will share them with you. All right,
Yes, my
Uh,
apologies.
that's fine.
No, it's
So next week, Wednesday, the 20th of April at 2:30 PM on
Yes,
the
ma'am.
same platform.
I'm
Yes,
obliged.
ma'am.
And Ms.
Alright.
O'Flynn can send them electronically to me, that's fine.
Okay. All right, thank you, Council. Good
Thank you.
afternoon.